Welcome to this module of the HR and Volunteer Management course. This module is titled Library, HR, and the Law. Much of this information in this module was taken from a webinar that our state law librarian, Mandy Easter, and I previously presented as part of the state library's continuing education series about HR. I want to credit Mandy with much of the content and the legal information being shared in this module. My name is Mary Ann Morey. I'm the District Consultant for Central District with the State Library of Iowa. At the completion of this module, you should be able to define basic legal concerns pertaining to employment at your library, explain best practices from a legal perspective regarding supervisor and employee relationships, and write sample interview questions for library employee or volunteer openings. Let's look at some basic legal concerns pertaining to employment in an Iowa public library. If you have completed the endorsement course about library laws, you know that the library's ordinance is a legal document adopted by your city and based upon state law. Your library ordinance established your library and defines the operations of your library board. In Iowa, the vast majority of public library ordinances gives library trustees the power and authority to hire their library directors. You might also recall from the Laws for Libraries module in the library law course that we had an entire section of laws pertaining to HR aspects. As you can see here, there are laws, federal and state laws, that pertain to employment, and public libraries must adhere to these laws. I want to focus this section on the first two laws, those about child labor and veterans' preference in hiring. Some of our public libraries rely on the work of teens to staff their part-time positions at the library, and that is an acceptable practice. However, you should know about Chapter 92 of the Iowa Code. Chapter 92 is titled Child Labor and applies to all workers under the age of 18. There are legal restrictions on the kinds of jobs minors can do and the hours they may work, especially 14 and 15-year-olds. There are fewer restrictions on 16-year-olds and even fewer on 17-year-olds. Since the public library is a popular place for teenagers to look for their first job, familiarize yourself with the laws regarding their employment, the regulations concerning work permits, and any city policies pertaining to minors on the payroll. Our state law librarian has this to add to this discussion of hiring teens. While there are no child labor laws prohibiting teens from working alone in libraries, a minor in charge of a city agency is considered a legal liability for the public employer for many reasons. Minors working alone can easily become the target of perpetrators, whether they're thieves or rapists, and then the city could be held liable for negligently putting a minor in harm's way. Some employers have discovered that when a teen is left in charge, other teenagers descend on the work site to bully their peer into allowing them free merchandise and special privileges, sometimes actually taking over the establishment. Could something like this happen at your library? If an unstable or irate patron came into the library when a teen was working alone, there would be no adult to diffuse the situation, which could result in a negative outcome for both the minor and the city. If there were an emergency of any kind, a tornado siren, a fire, a burst water pipe, an injured patron, a child in danger, a confused senior citizen, would the minor know what to do and have the wisdom to handle the crisis appropriately, or would the minor inadvertently create a liability for the city, possibly requiring an expensive legal settlement? Many libraries and businesses alike find leaving a minor in charge is risky at best, and they simply avoid the liability. If you feel you must leave a minor employee in charge of the library, check with your city administration to make sure the city's insurer and the city attorney are okay with it, and then limit the amount of time that a minor is alone to the least number of hours possible and at irregular, unpredictable times. A question that the state library often fields is one that pertains to the advertisement of a job opening at the library. This is when we remind trustees and directors about veterans' preference. Even if this state law didn't exist, your library should still want to promote equal opportunity employment by openly advertising all available positions. While there is no law or regulation that requires where you must post job openings, the Veterans Preference Law, which is Iowa Code Section 35C.1, does require cities to post public notice of the application deadline to fill a public job, and your library jobs are considered public jobs. The public notice of the application deadline must be posted 10 days prior to that deadline. The posting requirement is the same as for posting your library board's meeting agendas, in that the notice is to be a paper notice that is to be posted in a prominent place which is easily accessible to the public and clearly for that purpose. From our state law librarian, quote, "The fact that a city has advertised for a position in a newspaper or other publication does not fulfill the posting obligation of this statute. Remember that you must have a paper posting of the job in the same manner you need to have a paper posting of your public meetings." While posting is the legal requirement, advertising open positions in local or regional newspapers or on professional specific websites such as the state library's job list, as you see on the slide here, is still the best way to secure a large pool of qualified applicants. Even if your library anticipates hiring from within, you should still post the job to the public. The spirit of the Veterans Preference Law ensures that everyone has an equal opportunity to work for the government, that the best candidates have been sought for all public positions, that only the most qualified people work at all levels of government, and that when applicant qualifications are equal in every other way, veterans are the preferred candidates. While a member of the library's current staff may be the obvious frontrunner for an open position, he or she should still submit an application and compete for the job alongside all the other candidates. If the current staff member is selected to fill the position, that person's superiority over the other candidate should be well documented for the record, and the hiring decision should be above reproach. This practice protects you, the director, from any accusations of favoritism regarding the hiring of library employees, and in the case of hiring a library director, the practice protects the library board. A reminder about those job postings. Job advertisements are subject to a few easily met legal guidelines. The Iowa Administrative Code prohibits any employment preference, limitation, or specification based on sex or age. Listings should never specify male or female, nor should they contain terms or phrases expressing an age preference, such as young or high school student or recent college graduate. Library directors and staff are city employees, so legally, all library-related hiring practices, procedures, and policies should be identical to the city's. And if they're not identical for some reason, at the very least, they should not conflict with the city's set and approved personnel protocols. Many libraries believe they must conduct background checks or drug tests for potential employees. But our law librarian has previously shared this information with us. Quote, "There are no state laws mandating background checks or drug tests for public officers or employees. The library board, when hiring a director, and the director, when hiring staff, should follow the city's established processes and procedures. In other words, if there is no citywide policy or municipal ordinance in place affirmatively requiring background checks and/or drug tests, the library should do neither, or it risks a hiring discrimination lawsuit. When these tests are required by an employer, they are administered only to the prevailing candidate after that candidate has accepted the offer of employment, conditional, of course, on the assumption that he or she will pass the test. So the tests are not given to every employee, the tests are not given to every applicant, just the one to whom an offer is made and subsequently accepted. The Iowa League of Cities published an article that stated, quote, "Employers are well advised to consider the risks that come with the use of background reports when making personnel decisions." Some HR laws will affect the relationship between supervisors and employees, so let's look at some of those now. One of the best ways to avoid problems in supervisor-employee relationships is to avoid hiring individuals that are legitimately a conflict of interest. Our trustees handbook talks about this topic in more detail. Realize that not all possible combinations of public office have been tested in the courts or by the Iowa Attorney General's office. However, the following office noted on the slide, specifically applying to libraries, are considered incompatible, meaning that one person should not hold both offices at the same time. A city council member should not be a library board member. Your city clerk should not be a library board member, and your mayor should not be a library board member. Another example of potential conflict of interest is having a board member whose relative is a library staff member. The employee may go around the director to take concerns to the board member when the issue should be resolved by the library director and the employee. Allowing this type of situation to continue undermines the authority of the director. If you want to maintain a good relationship with your library employees, it is important to understand the need to adhere to standard set working hours. Both library boards and directors need to understand the laws regarding overtime. Cities and library boards cannot simply make positions salaried and insist that those employees are now exempt from overtime laws. This information is from the U.S. Department of Labor's Wage and Hour Division, which says, to qualify for exemption, employees generally must meet certain tests regarding their job duties and be paid on a salary basis at not less than $684 per week. Job titles do not determine exempt status. Our law librarian further explains, the employee must fit the Fair Labor Standards Act definition of an executive or professional. After meeting the salary requirement, library directors are exempt from overtime if they directly supervise at least 2 full-time equivalents and have the ability to hire or fire, or at least the ability to make hiring and firing recommendations that carry significant weight. After meeting the salary requirement, library staffers are exempt from overtime if they perform work requiring advanced knowledge based on a prolonged course of study, such as a master's degree in library science. If you or your employees do not meet these requirements for exemption from overtime, then you are non-exempt and must be compensated for all the hours you work. If you are determined to be non-exempt, you or an employee may be tempted to work extra and simply say that you're volunteering for the library. Don't do that. The Fair Labor Standards Act, or FLSA, strictly prohibits employees from volunteering their time to their employee or negotiating for a lower overtime pay rate. Title 29, Section 785.47 of the Code of Federal Regulations, which is what I have referenced on the slide, says that an employee who is performing regular job duties is indeed on the job and must be compensated for that time. Employees cannot donate or volunteer their time performing the same duties for which they are normally paid. Contrary to popular belief, no state or federal statute requires work breaks of any kind for employees who are at least 16 years of age. The U.S. Supreme Court has ruled that employers must allow workers to use the restroom whenever necessary, but mid-shift and lunch breaks are customary rather than mandatory. So unless city ordinances or library policies give all employees paid breaks, directors are free to set schedules that effectively and efficiently manage the library's staffing issues. Obviously, the extent to which directors are flexible and accommodating regarding employee break times will have an effect, positive or negative, upon relationships with employees. Some libraries offer 15-minute paid breaks for every 4 hours worked. Lunch breaks, whether 30 minutes or 1 hour, are typically unpaid and offered only to full-time employees. Talk with your city about employee practices regarding break times in order to ensure similar practices at your library. In the In Service to Iowa book, Standard 28 says, the library allows staff at all levels to participate in continuing education opportunities during their work time. This standard simply reminds libraries of the legal aspect pertaining to employee training. Standard 23 addresses the same issue when it says the library allows the director to participate in continuing education opportunities during their work time. Standard 23 is a Tier 1 required standard, while Standard 28 is a non-tiered standard. This practice is not only a best practice for having good relationships between supervisors and employees, but it's also mandated by the Fair Labor Standards Act. Again, our law librarian helps us understand this a bit better. She tells us the FLSA states that, quote, employers must pay for employees' attendance at meetings and training programs if the employer requires attendance, or if in fact the employee is given to understand or led to believe that current working conditions or the continuance of employment would be adversely affected by non-attendance. If any meetings are outside the city, travel time is generally counted as time worked if the employee does not stay overnight. If it is an overnight trip and travel occurs outside the employee's regular workday, the time need not be counted as hours worked unless the employee actually performs work for the employer while traveling during those regularly unscheduled hours. That information again is from our law librarian. We often get asked if a board member can work as a substitute or actually become a paid staff member at the library. Perhaps a better question is, should a library trustee sub or become an employee at the library? And the answer to that question is no. Although it is technically legal, it is not recommended. Having a trustee in a library employee position, whether as a volunteer or a paid employee, puts the library director in the position of supervising someone who is actually his or her employer, which creates a difficult situation if the board member's performance is unsatisfactory. The Attorney General's office has told us that it should not be commonplace for trustees to work in the library because it is not a best practice. It's better to have a core group of volunteers to call on, and better yet, to have a library assistant who's actually on the payroll. Here's a related situation. Library trustees sometimes think they oversee library staff other than the library director, but this is not so. The Iowa Library Trustees Handbook clearly states in several different places that library trustees' responsibilities for staff begin and end with the library director. It is the board's duty to employ a competent and qualified librarian to serve as director, and that director then hires, oversees, and evaluates other library staff. The board only oversees the library director. The director oversees all other library staff. However, the director is accountable to the board for the performance of all staff. The board has no direct responsibility for day-to-day supervision of staff other than overseeing the director. Board members have no authority to issue orders to staff or make demands of staff except through the director. If staff members go around the director and take concerns and complaints directly to the board or to individual trustees, it is the trustee's responsibility to remind staff to report to the director. The board does not act on complaints from staff except through a formal grievance procedure outlined in personnel policies. The board has no direct responsibility for assessing staff performance other than the directors. As part of the accreditation program, the state library's standards require the board to evaluate the director annually in order to be eligible for state funding. One of the director's roles in overseeing other library staff is to evaluate library employees at least annually. This is not just a good practice, but it's also one of our standards, as you see on the slide, standard number 26. Having a good relationship with your employees obviously makes evaluation time less stressful. Be sure to view the module in this course about job evaluations if you haven't already done so. That module will go into more details about conducting job evaluations. Let's look now at our final objective, providing you with information that will enable you to write sample interview questions for library employee or volunteer openings. Keep in mind that even if you don't have other employees at your library, you will likely be utilizing volunteers to assist with various tasks at the library. Just as you want good employees working at the library, you also want good volunteers serving there. Interviewing potential volunteers before approving them for service is a good practice that can help prevent problems down the road. Potential employees or volunteers should complete an employment application or process, and volunteers should likewise complete a volunteer application. The volunteer application will look very similar to an employee application. You shouldn't have to create such an application from scratch. Check with your city for a standardized application. There are also many samples available online, or you can contact organizations such as Iowa Department of Workforce Development, the Iowa League of Cities, or your state library district consultant. As our state law librarian has told us, quote, "The key to a successful interview is preparation, organization, and planning. Take time to prepare solid, objective, job-related questions based on the requirements of the position as set out in the job description and the advertisement. Ask those exact same questions consistently to all applicants in order to ensure equal treatment during the interview. Organize your questions into a logical sequence. Listen attentively to the answers generated by your questions. Present information about the job accurately, clearly, and consistently to all applicants. Having a reliable plan and process for your hiring and interview process is key to successful hiring. It is imperative that you avoid discrimination during the hiring process. Under several state and federal laws, discrimination on the basis of sex, race, color, religion, national origin, age, disability, gender identity, or sexual orientation is strictly prohibited. The Americans with Disabilities Act requires all employers to ensure equal employment opportunities to persons with physical or mental disabilities who are qualified for the jobs they seek. Employees must make reasonable accommodations for disabled employees who are qualified to perform the essential functions of their jobs, unless such accommodations would impose a provable undue hardship on the operation of the organization. Realize that there are certain questions that are completely illegal to ask in a job interview, such as the ones you see on the left-hand column. Instead of asking these questions, you may ask the types of questions you see on the right-hand column. An employer should inquire only about an applicant's qualities that directly relate to actual job performance. Keep in mind that the goal is to find the best possible match between the requirements of the job or volunteer position and the experience, skills, education, and characteristics of the applicant. Interview questions should be related to that goal. Keeping this thought in mind, these next slides will look at some types of questions you should never ask in a job interview, and this information should apply to volunteer interviews as well. Do not ask questions designed to elicit someone's age. Do not ask what year the person graduated from high school or college, since the answer to that question could provide clues to a person's age. Do not ask an applicant's height or weight. Federal courts have said that since there are virtually no jobs that can be performed by only one gender, any question asking the applicant's sex should be omitted from the hiring process. This also complies with Iowa's law, which prohibits discrimination based upon a person's gender identity. Do not inquire about applicants' arrest records. An arrest is no indication of guilt. You may ask about actual criminal convictions, but the fact that an applicant has been convicted of a crime cannot be the sole reason you reject the person. The Equal Employment Opportunity Commission has said that an employer may exclude an individual from consideration only after carefully considering and documenting the nature and seriousness of the offense, the amount of time that has passed since the conviction or the completion of a prison sentence, and the relevance of the crime to the nature of the job being sought. Do not ask questions regarding an applicant's past pregnancies or future childbearing plans. Federal law prohibits employment discrimination based upon birth-related medical conditions, including abortion. Iowa law prohibits such discrimination in all hiring, promotion, and employment termination actions. Do not ask, "Do you have a family?" or "Do you plan to have children? When?" Instead, you can ask, "Would you be willing to relocate if necessary?" Or, "Travel is an important part of the job. Would you be willing to travel as needed for the job?" Or, "This job requires overtime occasionally. Would you be able and willing to work overtime as necessary?" These questions are all okay as long as they are asked of all participants for the job. Do not ask about an applicant's past, present, or anticipated marital status. You cannot ask for a maiden name on an application. You cannot ask if the applicant prefers to be addressed as Miss, Mrs., or Ms. You may inquire about all the names used by an applicant, but both male and female applicants must be asked the same question. Do not ask for an applicant's spouse's name or the spouse's place of work. You may ask about friends and family working for the same employer in order to comply with any nepotism laws. Tied along with those last couple of slides, do not ask about family responsibilities or child care arrangements. Information about dependents for tax, insurance, or Social Security purposes can be obtained only after the applicant is hired. As I said earlier, you may ask if the applicant can meet the requirements of the employer's work hours as well as overtime, travel, and attendance policies. Federal and state law prohibits discrimination on the basis of national origin, which means questions about an applicant's citizenship must be handled correctly. It is illegal to knowingly hire an undocumented resident, and employers must verify the employment eligibility of all new hires. Therefore, the appropriate inquiry is, can you, after being hired, verify your legal right to work in the United States? Another acceptable question is, are you a U.S. citizen or otherwise eligible to work in the United States? This question must be asked of all applicants and not just those who appear to be from another country. Under the Americans with Disabilities Act, it is unlawful to ask whether an applicant is disabled or to inquire about the nature or severity of an obvious illness or disability. Do not ask if the person has ever been hospitalized or treated for a mental illness or addiction. Do not ask if the applicant has ever filed a workers' compensation claim or was ever injured on the job. Do not ask if the applicant would need time off for medical appointments. Employers may ask questions about the person's ability to perform the essential functions of the job, and they may also ask an applicant to describe or demonstrate how, with or without reasonable accommodations, the applicant can perform job-related functions. However, these questions must be asked of all applicants and not just those suspected of a disability. Applicants may be asked to describe the quality and quantity of previous job functions and tasks performed, as well as the applicant's attendance record. Federal and state laws protecting the disabled do not interfere with the employer's right to hire the best qualified applicant, nor do these laws impose any affirmative action obligations. They simply prohibit employers from discriminating against an otherwise well-qualified candidate or employee simply because of a disability. That's a long list of do not ask questions, and by now you may be wondering, what kinds of questions can I ask? Well, here are some samples that you see on the slide. All of these questions are acceptable and legal interview questions. Why did you leave your job with your previous employer? Or why are you thinking of leaving your present job? Describe a typical day at your previous or present job. What particular parts of previous jobs did you enjoy the most or the least? In what areas of past jobs did you have the most success or the least success? How does this job relate to your work experience? What relevant experiences do you have that fall outside paid employment? What is your educational background? Why did you select your college major? What do you think your past or current supervisors will tell us about your work performance? Have you ever been warned or suspended for violating a company work rule? Have you ever been discharged or asked to resign from a job? If yes, please explain. Under what type of supervision do you work best? I'm going to describe a type of problem that comes up in this position. How would you handle it? If selected, how soon would you be able to start? Knowing the laws and legal considerations of employment aspects can help you avoid complications later down the road. Talk with your district consultant. If you have any HR concerns, you can also contact an HR person if your city has one, and if so, be sure to communicate with that person regularly. Additionally, our law librarian has developed this library law FAQ page on our website. The information provided here is searchable. As you can see on this slide, a sample search for human resources gave 16 results. This site is easily found on our website. Contact your district consultant if you need help locating or using it. This concludes our module about HR and the law.